To that, though, I'd like to just point out to you that the legal issues that NYSAR faces are really on the grounds of education, risk reduction. We have legislation and regulations, and we also have the Legal Action Committee initiatives. And we've had a couple of banner years in a row, and I'd just like to recall that to your attention. In 2008, we had 2 cases in our top state court that dealt with key issues affecting our industry. The first was the permissibility of having multiple buyer clients seeking the same property, and our Legal Action Committee initiative succeeded in Rivkin versus Section 21 Terran Realty in upholding the validity of having those multiple buyer clients just like we have multiple seller clients. We also had a success in upholding the utility of the attorney approval clauses in our contracts that are broker prepared in a case that is called Moran versus Irk. This past year, we've had 2 other successes that I'd like to bring to your attention. We had a case down in the Hudson Valley where a licensee, a listing broker, had been cited for the obligation for substantive code compliance on the listed property. And we were successful in a declaratory judgment action in getting a ruling that that marketing agent is not responsible for the substantive compliance of the listed property. That's Tucker versus the Village of Wesley Hills. We also had a key case with respect to MLS sales tax audits. And as you may or may not know, in New York, the sales tax law provides that pre-written software is taxable. And that caused some audits coming around the state with some high price tags associated with it. And we were successful in a test case to establish that you can allocate some of the charges to those software vendors to non-taxable services, such as data storage, such as customer support, installation, or customization. So those are just examples of the way that your Legal Action Committee is trying to stay focused upon things that will matter to you substantially in your business and to the costs to your boards. In addition, we have a couple of legal action matters pending at these current meetings, and one involves a challenge by a current seller claiming that the listing broker for the property that was listed in the MLS should have protected that seller against a claim by another broker that they had a prior oral listing with respect to the property. And what happened was that prior oral listing, that contention was sued against the seller, and the seller then impledes the listing broker and says, hey, you're supposed to clarify and find out what's going on with this prior claim, and you're also supposed to protect me against owing 2 commissions. Well, I think you can see that that's a pretty difficult position for the listing broker to be in. You're not supposed to be giving legal advice. And you're not necessarily supposed to be giving up your contract rights because somebody else claims a commission. You know, NAR has, under Article 17 of your Code of Ethics, an ability to sit there and arbitrate contractual disputes and certain non-contractual disputes. And there is a provision if there are 2 claims to cooperating broker status that can be arbitrated. But this particular test case that we have isn't 2 claims to cooperating broker status, but rather 2 primary claims, each saying I have a listing agreement that's valid. In any event, Legal Action Committee is going to consider whether or not to support that case. Additionally, there is a case that's pending in the western part of the state having to do with election law compliance. RPAC is very careful with respect to the contributions it gives to candidates, and we also have ballot initiatives run through realtor advocacy committees. And in this particular case, there's a challenge given to the filings that we've made, and that it'll be before legal action. Separate from the legal action initiatives, there's been 2 key pieces of legislation that you, I'm sure, are familiar with. As of the 1st of this year, we have the Commission Escrow Act that's in place around the state. We've been asking for anecdotal reports of the utilization of that. There are several apparent successes in the Hudson Valley, but by and large, there hasn't been a lot of utilization yet of those affidavits entitlement to commission and then using the escrow deposits. So if you could advise your local boards and bring that information to NYSAR, it would be helpful for us to get a fuller appreciation of the effectiveness of the current legislation. There's also, as of the 1st of September of this year, new statutory short-form powers of attorney in New York, and they have, among other changes, a major gifts rider if you're going to have the power of attorney authorized to give gifts in excess of $500 and gifts that would be possible to the actual holder of the power of attorney. I think, though, the most important issue that's before this body in these meetings are the current pending regulations that the State Board of Real Estate has developed on June 24th of this year. Now, the State Board of Real Estate came into effect in 1996, and it has its own regulatory jurisdiction. It has as one of its major component parts the Secretary of State, but the State Board has authority to adopt regulations that affect your industry. And after the Department of State developed a proposal, the State Board of Real Estate in June, in fact, has proposed these regulations and forwarded them to the Governor's Office of Regulatory Review, GORE. Now, that Governor's Office of Regulatory Review has the ability to review regulation proposals and determine whether or not they should be allowed to be published in the state register when they therefore go forward to be considered for public comment. And among the kinds of considerations that GORE can take into account are whether or not the regulations are consistent with current state law, whether they will produce public benefits that outweigh the costs, if any, on the affected parties, whether they allow regulated parties flexibility and encourage innovation in meeting legislative or administrative requirements underlying the rule, and if possible, they favor market-oriented solutions and performance standards over command and control regulation. And I think as we go forward to hear about the new regulatory proposals by the State Board of Real Estate, you'll see that GORE's review standards may be quite helpful to this organization. Now, the Article 12A committee here reviewed yesterday the current proposals to the regulations that's now at GORE. And if you haven't had an opportunity to see that packet of information, I would recommend it to your attention. It includes copies of the current regulations in New York, the current advertising guidelines for regulations in New York, and finally the current proposal that the State Board has put forward. And at tomorrow's Legislative Steering Committee, there's going to be further consideration of a proposal that the Article 12A working group came forward with, which is to ask GORE to recall or to bring back the regulations to the Department of State so they can be completely reconsidered. In New York State, the regulation of advertising is really quite limited in terms of substantive or positive law. There's a statute that provides that you're not supposed to have fraudulent practices, that you're not supposed to have dishonest or misleading advertising, and you're supposed to be trustworthy and competent. But that's really the only source of substantive statutory law that exists. In addition, there's a very simple regulation, 175.25, that says that all advertisements placed by a broker must indicate that the advertiser is a broker or give the name of the broker and his telephone number. The only other regulation we have provides that advertisements placed by a broker that state properties in the vicinity of a particular geographic area must include as part of the advertisement the geographical area or territorial subdivision where the property is actually located. Those requirements in that simple statutory provision about dishonest and misleading advertising, and secondly, that very short regulation indicating that you have to indicate the advertiser is a broker or give the broker's name and the broker's telephone number, are the only current law in New York. In 1994, New York developed some advertising guidelines, and those guidelines essentially guide the discretion of the Department of State as it does adjudications with regard to licensed disciplinary cases. The guidelines themselves aren't substantive law, but they are, in fact, pretty much a statement of the principles followed by the administrative law judges in implementing the requirement that you not have dishonest or misleading advertisement and that you be trustworthy and competent. In any event, then, we have the Department of State recently proposing some new guidelines and new regulations, in fact, to the State Board of Real Estate